In today's very shifting world, would you employ yourself or employ someone without knowing your full rights and your full obligations? In both aspects, in the work environment and on the marketplace, these are very valuable assets that you need to have in hand before you actually commit. The employment law essentials today are being discussed with our guest speaker, Dr. Beverly Tonna. Beverly Tonna is a doctor of laws who has specialized in the employment law essentials. Make sure you get them right. This is not worth missing.
Kick off, we do need to say something about employment, because a business is really nothing more than a bunch of people who actually work together and make a business happen. So the fact that these people are together, they need to be working in harmony. They need to be working in tandem, because if there is discord, then it's going to be a very uncomfortable relationship for everyone. And as we've said before, if you have a happy atmosphere at work, if you have happy employees, you're also going to have happy customers. There is no doubt about that. But at the outset, I'd like Beverly to introduce herself and her field of expertise in this manner.
Okay, so hi, for those who don't know me, I'm Beverly Tonna, and I have a law firm called Novo Legal, together with some other of my partners, and one of the areas that's of interest to us is employment law. We've been quite active in this field, and we have actually garnered quite a lot of experience, especially due to COVID-19 and the disruption it has left in so many fields of law, but particularly that of employment law. We set up a free legal clinic actually during this pandemic, so that we can allow all to reach out, whether employees or employers alike, to ask us questions on what their stance is at law. So today we wanted to bring this to our group.
Yes.
And offer again the same kind of feedback.
As I said, this is a subject that interests both employers as well as employees, because there is a little bit of haziness, of a cloud situation, because most people have no idea of what their rights are, but also what their obligations are, both as employers and as employees. At the outset, when someone is looking for an employee, we will also go at some point in time into the qualities that one should be looking for in an employee, because in an ideal situation, you will already know your employee, because in an interview, you get a feeling of what that other person will be able to contribute to a firm, to a company, to whatever business that is going to be employed. So if you're an employer and you're interviewing an employee, you gauge on the feeling. But no matter how good your perception is of that person in front of you, you are basing a decision on practically a few minutes.
Exactly.
And the same goes for the employee. The employee has to see whether he or she is going to have the affinity with her or his boss, as well as with the rest of the team, if this is going to be a question of teamwork. So with everything else being equal, in the hope that everyone is a good fit together, when someone is being employed, today, at least in Malta, by law, no one can be employed unless it's with a contract, right? What are the different types of contracts, and what should one be looking for, on both aspects? Because a contract binds two parties.
Correct. So when we were preparing for the session, we were actually discussing this. That for me personally, it's been a short time going from employee to employer. And as Mariella rightly stated, it's true that especially in professions, many a time you would think, let me look at the CV, let me look at the qualifications, let me see what kind of masters this person has. But really and truly, seeing it from both aspects, what impresses the employer the most, or rather, what should impress the employer the most, is how this employee is going to fit in your team.
Exactly.
How this employee is going to enhance value, not just from a certificate point of view, but also from a team dynamic point
Exactly.
of view.
Qualifications, unless you're looking at a very specific profession, where in that case, if you have an engineer, you need to have an engineering degree. If you're looking at a legal aid, you need to have. But in other terms, in the more arty, so to speak, employment situations, the qualifications don't really matter that much, because it is actually the synergy that is built on the workplace that is really important. But let us assume that everyone has, said the proverbial yes, and you're sitting down and you're negotiating a contract of employment.
Correct. So when you're negotiating a contract of employment, what we suggest is the first thing you have to look at is what kind of contractual relationship are you entering into? Is it one of a definite nature or one of an indefinite nature? So when we think about employment contracts, or when clients approach us and ask us how to structure their employment contracts, they would usually be the employer. We say, is this going to be for a fixed time, for a specific purpose, or is this going to be a long-term relationship? Depending on that, you would go into whether it's a definite contract, so this would be for a fixed period of time, or whether it is an indefinite contract. So the name says it itself, indefinitely employed. Now, both these contracts provide you with different rights and obligations. So if it is a definite contract and you are entering into it for a specific purpose.
Let's assume this is a situation where you need someone specifically for a year to fix your marketing department.
Yes.
So you're employing someone for a specific year with a specific job outcome.
Yes, you would pre-agree on the rates for that particular service, but you, as an employer, you are stating, look, you have a year, and I will adhere to my obligation to employing you for this year under these conditions. As an employee, you know that for that year you are bound by those conditions and you cannot opt out.
So in this particular case, no one can technically, unless by agreement, get out of this contract.
If you do get out of this contract, then you need to pay the price. So if you have a definite contract and you just opt out of it before the period elapses, then you would need to pay back, if you're the employer ending it, pay back the employee half what was due. So it is not possible to just opt out of a definite contract so easily. Here we see that in the case, at least of Maltese law, the employer and the employee are on pretty similar standing when it comes to a definite contract. They both have kind of
the same rights and the same obligations. I usually, whenever I am employing someone, I exercise my right to employ with a probationary period. So the probationary period is actually the testing time that I prefer to use, so that I can build the relationship and see whether this person is a good fit for my company and whether we are a good fit for them. Because sometimes I realize that some people are actually overqualified for what I would be, for what I might need. And then I would also, understand and give them the option to see whether they would like to stay or not. But this probationary period, by law, I am a little bit unclear about as to how long I can extend this, because when you have probationary period, you basically can tell an employee, you thank you very much, but you can leave.
Exactly, correct. So the way, that is one extremely important point to be included in your contract, and it is one of the misconceptions that people assume are like automatic without being considered. So like we discussed earlier, it would be responsible of me to say this is like a blanket provision for all contracts, because it depends on the jurisdiction, and it also depends on the area that you are working in because of very specific laws. But generally, when one is entering into an indefinite contract, meaning you're not seeing this relationship end, you would have a 6-month probationary period. Then if you have a fixed term contract, so we're saying, listen, this is a 2-year situation or a 5-month situation, not the same automatic probationary period
will apply. And during this probationary period, the employee is also allowed to take, his right to leave. In fact, there was something else I wanted to ask. In a situation which is ideal, you start off a relationship, because after all, employment is a relationship, and we actually spend so much time on the workplace that it needs to be a relationship which is a good and healthy and one which gives you fulfillment and satisfaction. Otherwise, you will really be trading your time for your money, and you're not actually getting benefit and satisfaction out of your job. But as it stands in Malta, the relationship between, in indefinite contracts, if you have an employee who has been working with you for 2, 3, 5, 10 years, and who you've invested a lot of time and energy to train, if you're really happy with this employee, naturally you try to give perks, increase salaries, increase even maybe job description. We'll go into that later. However, the employee always has the right to give you a leave of notice,
right,
and actually terminate the relationship.
Yes.
On the other hand, an employer who finds that one of the employees for some reason doesn't remain a good fit in the organization has no right to ask the employee to leave.
Correct. So the way employment laws, especially locally, we think are a little bit outdated. They are very employer-centric, so they're employee-centric, apologies. So the employees have far more rights than the employer does. Another clear misconception that we see many questions being asked about, and because of COVID-19, there were a lot of questions about this, is how do you fire someone legally? This is a question we're asked very
I
frequently.
was trying to, put that in a very sugar-coated. How do you ask an employee to leave because he doesn't remain the right fit?
So in Malta, we adopt the last in, first out principle. Now, this principle has different implications according to the size of your business. So if you have a large business, you employ, 50 people plus, and there are different levels and different categories of employees.
Different job roles, different job descriptions, different salaries.
Last in and first out will apply for each different category. So to be clear, give an example. If you're a hotel operator, you own a hotel, and you have your managerial staff, and then you have your cleaning staff, and then you have the staff that work in a restaurant, they all might be bound by an indefinite contract, but let's call it type A, B, and C. So the last in, first out rule would mean that the last person employed is the first person you can let go by law.
Especially given the circumstances that we are facing at the moment, where some people have had to, whether they like it or not, release some of their extra stuff. So this is the only way. You can't, so to speak, select from your basket of assets.
The usual question would be, but what if the person that I want to keep is the one I employed last, and the one I employed before that is someone I want to let go? You cannot do that at law. What you can do is, and this is something we suggest, implement a disciplinary policy within your firm or within your outfit, so that you enter into small caveats which employees agree beforehand on how termination works. So, for example, to be practical, the 3 warnings system. This is something that's very commonly and very widely adopted, but it's not actually emanating from the law. It is a principle that you decide to have in your business, and this is something.
So you are recommending that when you employ in the first place and you're doing the contract, which is for an open term, that you enter this caveat that if someone is not adhering to rules, or that the disciplinary action would be by a warning system.
Whether it's a small business or a large one, and this will depend on the manuals you will adopt, it is always very advisable to have a disciplinary policy which you will attach to your human resources pack when someone is joining your team, so that your employees are clear that when signing the contract, they're adhering to these side rules.
This is quite interesting. And what's also interesting is that the nature of work, generally speaking, all over the world has really changed because of social distancing, because of people who have to be quarantined, and also for some period of time earlier on in this year, there were situations where the schools were closed down, and therefore parents had to be at home with children, which automatically rendered them incapable of giving a service in a place of work where they had to be present. And so obviously this must have created quite a lot of havoc in the system, and also in the way people employ, because first and foremost, not all jobs can be worked remotely. If you're, for example, you mentioned hotel business, if you have housekeeping, you cannot do it remotely. You have to be physically present. If you have shops and you have salespeople, you can maybe try to adapt and do them on a roster, but you need some of them to be present. Whereas other services, by nature of the service, will allow for more flexibility.
Exactly.
But how does one actually respect a contract in circumstances like this, although these are, unprecedented circumstances, really?
Yes, and it's interesting that you mentioned the term unprecedented, because on this note, even if the situation is as disruptive as a pandemic, the laws still needs to be respected fully. So you cannot say, my business is not doing well, I'm going to remove 5 people so that I have a better cash flow, without these considerations. So if it's having employees that can be teleworking, but the company policy states that you do not telework, then that is something you would have signed up for as an employee when signing your agreements. So what in the spirit of what you explained earlier, that the business is like, part of it's their family where you're working, because you're spending more time at work than you are spending at home. One would hope that the employer would employ this kind of attitude towards their employees.
Towards better flexibility. In fact, this is one very important factor. And
teleworking, for example, which is something that you mentioned as well, has caused us as lawyers to go back to the drawing board and start redrafting certain clauses in manuals, certain additional teleworking policies, because we got a lot of questions. How does this affect GDPR? How does this affect security?
For those who don't know, GDPR is
the data protection regulations. So if you're using your laptop from home and you're accessing your private things with your work things? How does that work out? Does the laptop become your possession all of a sudden because you're taking it home if it wasn't something
Do you
people are
have
using?
ownership of?
Can you use it for personal matters? Can you access your client's files from home? So many questions came about, both those personal and those with the client.
I would like to know if from the people who are actually watching live and those who will watch the repeat later, you can still put in your questions at any point in time, and we will come back to them and we will answer them to the best of ability. But obviously, if anyone has any questions during this live session, it would be appropriate to put in your questions now, because we will answer the questions as we go along. But rules and regulations apart, you mentioned something which is really valuable and important, and that is in the spirit of working in a community. I actually read quite a lot. I actually saw quite a lot of videos by Richard Branson, because he is considered to be the ultimate employer, and he has actually managed to achieve a level of employment success, which automatically means that you have a lot less in turnover in staff. Turnover in staff meaning staff who actually leaves after a short while. So you will have invested time and money in their training, and then you have to start all over again and from the beginning, which is a very expensive exercise for any company to do. But amongst other things, his blanket statement is one and only, and that basically is, if you have staff who are happy, it means that you are going to have happy customers. So that is a blanket statement, but then he actually refines it into this is billion dollars company. So the amount of staff and many different companies is massive, is huge. But then he goes further and says that when he employs the leaders of the teams, the managers of the teams, what he does is he employs people who actually like people.
Yeah.
Because when you have at the top, when you have at leadership, you have people who are warm and who are enthusiastic about the project that they're working on, and who are able to motivate the staff, then automatically the staff are better served,
100%.
basically. And another very important thing, which I think I took a lot from this, it was a very important take, is that he says that they exercise, and this can be done actually in every company, and this is exercising the walkabout. So what is the walkabout? The walkabout is basically when you have leaders. In his case, he does this sometimes himself. When he is on a plane, he actually watches what's happening with the objective eyes of the client, and then makes a list of snags that need to be corrected. Because one of the things that really puts down staff is clients' complaints. If staff have to constantly deal with complaints from clients, they are automatically going to feel that they are under pressure on the job, which in turn means that you actually need to sit down with your staff and give them a voice. When you give your staff a voice and you ask them to participate in an active manner on what they think that they can actually improve within the environment that they're working in, people who feel that they are being heard will actually be a lot more productive.
Correct.
And apart from that, there is no point in listening if you don't take any takes and implement the things that you believe are actually beneficial to the company. And when you share ideas, you actually grow exponentially.
Yes, to be fair, it gets a bit complicated, because to reach this level of communication at contract stage,
is very hard.
It's difficult. But even the fact that so many businesses are moving online, and there's such an influx of digitization, flexibility is automatic there, because there needs to be trust.
Exactly.
Trust between the employer and the employee. And like you're saying, trust is achieved when you see that your employer actually wants you to flourish and is actually implementing your ideas as well.
And on this stake, I would also say, like I said, I am very conscious of the fact that when I've employed someone, most of the time, there is an affection growing, because as you get to know people, when I employ, around 20 people in one particular company, so it's very easy to have a relationship, a one-to-one relationship. But with very huge companies, it's very difficult to have one-to-one relationships. But there should always be a team leader who has a relationship with, with a bracket of people. But I am very conscious about the fact of the emotional expense as well as the financial expense when you're going to lose staff. So ideally, in an ideal situation, you try not to lose stuff.
This is like when you're entering into a marriage, but you have a prenup because you just need to kind of try to cater for what, like mitigating the feelings, the actual emotional part, when things go sour in a marriage. So when it comes to a job, too many times the employees just go sign off and then after we're all concerned. Exactly. That is why you need to read the fine print. You need to reach out and get someone to maybe explain a contract to you if it's not your area. Ask questions. You don't have to I feel like at least in my generation, maybe younger generation, feel like, okay, I got this job, let me sign on and I'm excited.
Yeah, and when the honeymoon period is over, then you get to the reality and the crunch of day-to-day marriage.
From the employers, from the employer's point of view, on the other hand, the employer is not cheeky because the employer is putting in a warning system and a disciplinary policy, for example. But the employer is mindful and is actually giving you the opportunity to perform your job well. But if you don't, I will give you a warning. So this is another thing in our cultures we don't really do. We don't actually put in the warnings when a person is not doing their job, when an employee is not doing their job. And then we'll be annoyed about a number of things as an employer, and you'd want to lash out. No, you have a system in place, you have a disciplinary policy, you keep your end of the deal, and I will keep mine.
I am still, very much with the mentality that mostly you can solve most things by having a good conversation, by having an open line of communication. And that is why I also recommend that people, even if it's just a team of two, even if it's just yourself and someone else you're employing, but even if you're an employee, I would strongly recommend that you try to have staff meetings where you discuss it. Sometimes if you let a problem escalate, there is no solution. But if you start tackling a problem at its inception, the chances that this problem will not blow up in your face is, the chances are much better.
Communication is key, and striking a balance between the employer and the employee is always the way forward. In fact, you mentioned, yes, you get maybe some affection towards your employees, etc. It's good to have a bit of a personal relationship with your employees, because that will make them have more allegiance towards the company, for example, because you need to feel like you're working towards a common goal.
And that is also another thing. The goals must be made very clear from the top. There is no point in, staff do not read employers' minds. And therefore setting the goals right and working towards a goal when you have a specific goal is obviously the responsibility of whoever is in leadership. In reality, how many situations end up in arbitration?
Quite a number, actually, at least locally. The Public Contracts Review Board, which is the one that takes care of these issues, has been seeing quite a number of issues. And as time goes by, more awards are being given to employees. This is why I'm sounding a bit negative, but as a lawyer, I must emphasize the importance of contract. Because when employers have, with COVID-19 especially, taken it into their hands to just let go of employees because they feel like they have a divine right because their business is not doing well, this has not been received very well by the authorities that review such contracts. As a matter of fact, a lot of decisions have come back and said, no, employer, you had your policies and procedures, you had your human resources manuals outlining the way with which you should have treated the employee, but you did not treat the employee in the right way. You did not adopt the last in, first out principle. Yes, your business is struggling, but there are government incentives. Yes, your business is struggling, but you know the law, you know the rules. Claiming you do not know the law does not mean that the law does not apply to you, and therefore you need to rectify the situation.
In saying that when an employer gives a warning that this needs to be signed and acknowledged by the employee.
Correct. It needs to be given in writing, first of all, and to be made official. But again, if you have a disciplinary proceeding in a manual that states otherwise, that the employee would have signed for, then that no longer applies. So yes, you would need to have engage in a discussion with your employer, and it is essential as an employee, you know, that you can never be given conditions less favorable. So you cannot impose conditions less favorable on your employee unless the Department of Industrial and Employment Relations allows you to do so. So an example would be this COVID-19 change in salary. So if there was a wage supplement to be given, the department had to confirm that yes, there is going to be a deviation from your salary, for example. Otherwise, it's an automatic trump for the...
Another question. When employees have been in employment for a number of years, and because of the progression of years, because of their experience, and because they will have contributed favorably to the company, so they actually get incremental salaries, perhaps a promotion. Does that necessitate a new contract? How does that work out?
It does not always necessitate a new contract. It depends on the size of the business. So when it's, for example, a large company, usually salary conditions are placed in annex so that the normal and the crux of your employment contract remain the same, but then this annex just states you've gone from senior A to senior B, or from junior A to senior 1. They will be categorized. And the categories are of an essential nature for the last in, first out principle that we spoke about earlier. So that if you want to remove an employee, then you have to make sure that the last person employed in that area is removed first, and you have a right, at least locally, to be the first person to be re-employed in the next year, if this is for redundancy matters. So if now we're talking about a situation where, listen, I need to fire XYZ because I don't have any work to give them because of the situation, then the last person has to be fired, and nobody can be re-employed in that position unless the person fired is given the opportunity to join again within 1 year.
So the right of first refusal.
Right. Correct.
And so you technically cannot employ anyone for another year
unless you offer it to the person you are firing on the basis of redundancy.
Okay.
And they refuse. Then you can.
That's very clear.
This is why we're saying
very interesting.
So employee
Yes, the bias is towards the employee naturally.
What I'd like to make as a short point is that if you're changing your contract as an employee, make sure that your probationary period does not start to run again. So that's
Okay. So if for
Remain
some
with the same
reason you're staying with the same company, but changing the nature of your work, and you are starting with a new contract, that automatically it does not start running from day zero.
so that you can still have the same security you had before.
Yeah, you still have the same advantages. I think that this has been quite an interesting conversation. I don't know in terms. I mean, this is obviously
The tip of the iceberg.
yes, because in different spheres, in different types of works, different organizations, different also types of employment, you have different needs.
Right.
And different. But I do want to ask one other last question. Today, as we said, a lot of people are working remotely, and a lot of people are actually creating businesses which are digital businesses. And so basically, you can even employ a virtual assistant.
Correct.
For example. Does that still necessitate a contract?
I mean, ultimately, it's not an obligation per se to have a contract if you don't want to, but it makes absolutely no sense not to have a contract. First of all, even with banks nowadays, if you're going to transfer a payment into someone's account, how are you going to justify that payment? If you need to give a social contribution for the person who's being employed to have a pension, it is in their interest for them to be employed via contract. If you want to have
if you want to ask for a mortgage, it's the same thing. You need to literally show your contract of engagement.
So it makes no sense, really and truly, to not have a contract. You can have a flexible contract. You can decide on which jurisdiction, if it's a digital nomad kind of situation. But I would recommend a contract.
Very, very interesting. I hope you've really enjoyed the session. The rules and regulations pertaining to employment law are definitely not to be taken for a given or not to be taken for granted. Naturally, jurisdictions vary, and so do the employment rules and laws, and one would really recommend that you will always contact legal advice before you get employed or you employ people, depending on which jurisdiction you're in. If you've enjoyed the session, please hit on the like button as well as on the subscribe button, so we will show up with more interesting conversations like we've had with Dr. Beverly today, and I hope we'll be seeing you very soon next week. Thank you.